Thank you, Johannes. Thank you also for inviting us again to this compliance seminar. We've been to Copenhagen before, and we pretty much enjoyed it. And we also enjoy, obviously, escaping the so far quite dull German rainy winter and seeing real snow for the first time here in Stockholm. Thank you again. Maybe before I touch the subject that Johannes already announced, i.e. Particular issues that we came across with regard to business compliance, maybe allow me to lose a few words on our firm. We are around for some 140 years. We are originally an American law firm, but spread, if you want, across the globe. We are present in 18 offices in almost all major commercial and financial centers. Unfortunately, Stockholm is one city missing in our footprint. Maybe we can change that at some point. We are advising clients on all sorts of legal areas that are relevant for their business, but in particular also advising in the insurance and reinsurance industry and also intermediaries. We are advising on policies, on all sorts of agreements in this regard, on general corporate and governance matters, on insurance M&A and restructurings, recapitalizations, but also security offerings, you name it. So everything around the insurance industry we can cover, and also cover not only in Germany or the US, but we have a kind of multi-jurisdictional approach. So whatever your need is as a company, we are able to put together teams to cater for that. And obviously one area that has some prominence and is still emerging is compliance. Or as Johannes already put it, compliance is burdensome, compliance is expensive, that's right, but you also need to look at the flip side of the coin, and that is that non-compliance is definitely more expensive. I wouldn't go as far as Carol did and say that that you either have to comply or die. Let's see, don't know whether we are that far yet, at least not in kind of most civilized countries, but definitely, I think these days you cannot afford any longer a non-compliance. Shortly to myself, I'm a lawyer in the Frankfurt office of Shearman Sterling. I'm advising clients on corporate law, M&A, but also in particular clients from the insurance industry, also on regulatory and compliance issues, and I'm also the compliance officer of our firm responsible for Germany, so I share your pain when it comes to compliance, right? Having said that, we will only touch briefly on two selected business compliance issues. One is sanctions compliance. That may be more relevant for P&C insurers rather than life insurance companies, and then on international or global health insurance policies. So I hand the microphone, if you want, over to my colleague Hartmut, who will deal with the sanctions compliance, and I will say a few words after that on the global health insurance policies. Thank you.
Yeah, thank you very much, Andreas. I'm also a lawyer at Shearman Sterling in the Frankfurt office, and I'm the regulatory expert in Germany. And I would like to report some information regarding sanction compliance in Europe and as well as the US sanction compliance. I start with I think, most important definitions regarding sanctions, and will step over to the overview of worldwide embargoes and sanctions, and then to bring it to life, I will give you an example with respect to the Iran sanction regime of the European Union. The most important question for you and your companies is, how are you dealing with these guys? And I think, and if you are dealing with these guys, you have a big problem. And now I step over to the, I think from my point of view, the most important risk of non-compliance with sanctions. That's a reputation risk. You see, every non-compliance, every violation of sanctions will give you the chance to read your name in the newspapers, and that's, I think, the most important risks in this regard. Let me tell you something about the definitions and the terms. What are the sanctions?
Maybe if I could just jump in there with regard to the clipping right left at the top, that concerned investigations of the US regulators against non-US reinsurance companies on violation of Iran sanctions. So basically, even if you are a non-US insurer, you have to be very careful what you're doing. And so please pay attention to what Hartmut is saying.
Okay. What are economic sanctions? Economic sanctions are a political instrument to restrict freedom of trade, especially with regard to certain goods, especially military goods, weapon of mass destruction and such things. And they are ordered for foreign and security policy reasons against several countries and several legal and natural persons. A prohibition of any trade whatsoever is very rare used, and it's called full embargo. We come to this point later. We have mainly three types of economic sanctions. First, financial sanctions, freezing of funds and whatsoever, and trade sanctions with respect to products, and trade sanctions with respect to services. And you see, insurance is under trade sanctions services, but it has to do with trade sanctions regarding products. For example, the insurance for trade with weapons and nuclear technology is prohibited all around the world. Now you can see, now I come to some institutions which offers or which implemented sanctions in the past. First, the United Nations. The United Nations has had a broad variety of various sanctions against states and organizations. You see the example Al-Qaeda, and we have always these lists divided in natural persons and organizations related to Al-Qaeda. And if you have a look here, if Mustafa Abbas is your customer, always big problem. Then the European Union has several sanctions in place. They are directly implemented by several regulations, and they always contain an extensive list of people whose funds must be frozen, various types of trade sanctions. But European sanctions are always well aimed. They always want to protect civil population, and so no total prohibition, no full embargo is in place in the European Union. In the United States, we have the strongest sanction regime worldwide in place. Especially since September 11. It is implemented by several regulations, and we have an extensive list with natural and legal persons, the bad guy list. And in the US, we have total prohibition to trade with several countries, and this applies for US and non-US persons and companies. Yeah, what are the consequences in cases of violation? We have a very wide range of consequences. For sure, penalties and fines, imprisonment, up to the close down of your business, especially in the US. And of course, the reputational risks as well. Here there is a short overview of the current US sanctions which are in place. You see the red ones are the full embargoes in place right now. Iran is changing currently, but Cuba and Sudan is still in place. And Syria, I think it will be more intensive in the near future. Now we come to the example. As I mentioned, we start with the Iran sanction regime of the European Union. Why Iran? Because it's, I think, the most relevant, most strongest sanction regime of the European Union. And Iran is one of the largest economies in the Gulf region with huge oil and gas reserves. And it's still, I think, a very interesting place for business and will be even more interesting in the future. The Council regulation of the European Union contains several restrictive measures. It starts from the export and import restrictions, especially nuclear weapons, war weapons, dual-use items. That means products that can be used in a civil but also in a military way. It's mostly all about telecommunication products. And it goes up to freezing of funds and economic resources and restriction on insurance and reinsurance for any trade. Last week, everything changed in the European Union. Certain sanctions have been lifted for a period of 6 months because the European Union and the US came into a dialogue about the Iranian nuclear program. And as a result of this dialogue, the European Union lifted some, not all, sanctions regarding Iran. The suspension includes mainly the trade with oil and petrochemical products and the related insurance services. And it also contains some rules regarding the financial transfer, the transfer of funds. They have to be now only notified and not even authorized by the relevant authorities. Insurance under Council regulation is under the Council regulation, which is still in place, is general prohibited for insurance and reinsurance, and but that does not apply for brokering based in the EU to individuals acting in their private capacity, only if they're acting in the state capacity of Iran. And that's a general rule, and some detailed restrictions are in place for, as I said, export credit insurance for sale and supply for any trade with dual-use items, with nuclear developments, with military goods, and the insurance, the prohibition of insurance for the trade with oil and petrochemical products are currently suspended for a period of 6 months. Other restrictions are the restriction on financing of certain enterprises that are mainly state-owned Iranian enterprises, and freezing of funds of these enterprises. And a very important restrictions is the notification and authorization procedure for the transfer of funds and on financial services. An even more practical problem there too is that nobody will find right now a financial institution that still do business with Iran. So you can notify, you can authorize, you can get the authorization by the competent authority, but you will not find a bank that will manage the transfer in practice. The addressee of the European Union Iran sanction regimes are especially Iran itself, Iranians, Iranian entities and bodies, as far as they are listed in the annex, that are mainly persons that belongs to the Iranian regime, and for sure European enterprises who would like to trade with them. Practical consequences for your business are, first, you have to do due diligence and to get a sense of your business or potential business with the states or persons affected by the sanctions. Step 2 is to implement the sanction issue into your policy, into your company business. And as a last step, you have to implement the sanction issue in your internal structure, especially in your organization, in the assessment of risks, and in your escalation to other practices, management, and board.
Maybe one word about that quickly. That's obviously the trickiest bit, because you need to link up your person at the business front, the sales staff, with your compliance function, with your legal function maybe, and make sure that whatever they are not supposed to do, they're not doing. And if you look at the lists of goods, for example, you can't deliver to Iran, or you can't provide insurance for the transport of those goods or those goods itself. It could be that a ball bearing of a certain diameter is a prohibited dual-use good because it can be used in centrifuges for uranium enrichment, but almost the same ball bearing that is just a millimeter smaller or bigger in diameter may not. So you have to also see how you diligence that on the business side, how you find out what your client or your customer is actually transporting or wanting to have insured, and these are very tricky issues. The same with regard to the people on the blacklists, because you're dealing with foreign names, with foreign spellings. They're spelled differently, and I can tell you that certain names, if you kind of run them through an automated system, will give you a hit always. So do you switch that off? How do you deal with that? It's practically speaking, it is quite a tricky issue. And I would be interested, if somebody is doing P&C or is actually looking at sanctions, who of you has actually a system in place there, an automated or a compliance system that deals with these issues? Well, you see, I mean, obviously more relevant for P&C insurers, but it may also be to a certain degree relevant for life and health insurance, right? Okay, maybe we swap sides quickly. Now I will just, time permitting, say a few words on global health insurance policies. Obviously this is a subject where Munich Re and Ergo took a very proactive approach. So they engaged us to have a look into their business practice and to advise on compliance issues in this regard. And I will just give you a brief overview of general issues, and then I have selected a couple of country examples if you want. And for the interest of time, or in the interest of time, I may maybe only touch on the Obamacare issue that Johannes mentioned, because that seems to be one of the most interesting issues at the moment. So basically you will find that many European or EEA insurance companies actually offer health insurance policies with global coverage. Typical use is travel insurance, obviously, is student exchange, au pair, or studies abroad, expat insurance, and obviously also group insurance policies for employees sent abroad by their employers. how does that work? The insurance policy is usually sold to a resident in the given country where the insurer is authorized prior to the move of that insured person abroad. But we also see in some cases, in some instances, that policies are sold thereafter into the relevant foreign countries, and then obviously all the issues arise that Carol flagged in her presentation. Yeah, insurance is either prepaid for a certain period or is kind of paid from time to time via bank transfer, so that could also be an issue cross-border. And yes, when you're looking outside the EEA, you will find that usually you will not be licensed to do business in that relevant country. If you are, obviously you need to deal with the local licensing requirements. You're familiar with these, and you may or may not be compliant. But if you are not, you have to find out what the requirements are. You need to comply with. Sometimes you may have representative offices to deal with claims management and so on. Sometimes you may have fronting arrangements in place, but quite often in these kind of cases where insured people move across the border, you will find that they may end up in jurisdictions in countries where you don't have any representatives or business, and you maybe don't want to have that even. Now, when we're talking about these cross-border scenarios, we encounter several issues. Some relate to the insurance company, i.e. offering a policy with worldwide coverage may violate insurance supervisory law in certain countries. And that needs to be looked at on a case-by-case basis. As Carol already mentioned, and I'm quite grateful for that, some countries don't take an easy approach on that. Some foresee fines for violations. Others, such I think as Singapore, I believe, may even go as far as arresting one of your board members at the airport if you are in breach of their supervisory regimes and they don't find that funny. So this is indeed something you need to pay close attention to. Another issue for insurance companies may be that if an insured person moves abroad, in addition to maybe not being in compliance with regulatory law in that given country, it may well be, in some cases, we came across that, fortunately not the standard case, that the substantive law, i.e. the insurance contract law of the specific foreign country may apply all of a sudden to your insurance contract. We came across that, for example, in Turkey, that all of a sudden, after a certain time of kind of residence in Turkey, the regulator would take the view that basically Turkish contract law would apply to insurance policies that you may have kind of entered into with or issued to let's say, a Swedish resident. So, and also consumer protection laws may apply. So in that case, you might end up in a Turkish court litigating over an insurance contract that you thought is just between you and a Swedish resident. Then obviously you need to look at issues related to the insured person. So they might be obliged under local law to take out mandatory compulsory insurance, and you need to see whether your coverage, the coverage you offer, actually kind of satisfies these requirements. And then again, it may well be that this person is not only obliged to take out certain coverage, but it has to do that with a locally authorized insurer in that affected country. Last point you need to consider, and I won't elaborate on that, is obviously taxes and charges, and that may be a very important issue as well for when you kind of look at your business case. So what are the issues when you as an insurance company are dealing with an insured person that moves abroad? What could trigger basically negative consequences with regard to foreign regulators? It can be things like even correspondence with the insured person. That's something that is sometimes permitted, sometimes not. Sometimes you can talk about certain issues, others not. The collection of premiums and also the payments, obviously, of claims, and the engagement of local representatives to deal with your insured persons. Also, you may come across the need to adjust or amend your policies. For example, when you look at health insurance, usually that's at least what I find every year with my health insurance companies. They tend to increase their premiums. So you may need to amend the contract, or you need to maybe comply with compulsory regulatory law in Sweden, for example, and need to implement changes. Question is, if you do that, it's a change of the contract. If somebody is living abroad at that time, are you entering into a different contractual arrangement with that person, and are you conducting insurance business in that given country? Yeah, some regulators take that view, actually. So there you need to be very, very careful what is allowed and what isn't allowed. And then obviously the question, how do I deal with a customer who is already abroad? Can I sell insurance policies? Can I do it and contact that person? Can I only do it if I'm contacted by that person actively? And so that actually we found differs from jurisdiction to jurisdiction. Some take a very liberal approach. Some are very, very restrictive. And obviously, in the age of the internet, this becomes more complicated when you look at how insurance policies may be even sold over the internet. How do you kind of make sure that somebody from Ghana doesn't buy your insurance policy, and by virtue of that, you on your next holiday to Ghana, if you like, you end up in prison, right? Then, if you look at the insured person, as you may be aware, local insurance law sometimes or quite often states requirements for compulsory insurance for residents, but also, for example, for short-term visitors, for au pairs, and so on. And there are three models that we observed. First of all, could be that the policy must meet certain minimum coverage requirements, have a certain quality, or it must be recognized by local authorities, or even, and that's the strictest case, underwritten by a locally authorized insurance company. Again, a violation may trigger adverse consequences also for the insured person. On top of that, as I said, also you as an insurer may then be in breach of local supervisory law and may incur fines and even criminal fines. Okay, I touched on that issue already, so I make it short. The risk is finally that you think you have your risk under control. You know your terms and conditions of your policy. You know what that means. You know how your local courts and regulators would see that. But then all of a sudden you end up in a foreign court deciding on whether a certain event is covered and to what extent. So here you need to make sure that you have the appropriate carve-outs in your policies to make sure that you don't end up in these scenarios. I have a couple of examples here, and I will just scroll through them quickly. I believe you will receive our presentation, so you can, if you're interested, have a look at these examples. So Turkey is one where we have found that actually the authorities take the view that their substantive law applies after a certain time. The issue that is, from my perspective, most interesting, and we are in close contact with Ergo, DKV, and also ERV on this, is the so-called Patient Protection and Affordable Care Act, better known as to us as Obamacare, who for the first time stipulates a compulsory health insurance requirement in the United States. So we in Europe, and especially us in Germany, we know that for probably over 100 years. You probably also for quite some time. To the US, that's very new. It's a big project, and as I know from my advice to Ergo, it's still pretty much a moving target. So we, even though the insurance obligation entered into force for individuals at least 1st of January this year, there are certain issues that are still unclear, one has to say. So basically, under the new rules, US citizens and so-called resident aliens for tax purposes. So if you are resident, consider resident in the US for tax purposes, you have to take out health insurance that satisfies the requirements of Obamacare. Foreign insurance companies, and that was basically, I think, the status when we last talked about that in Copenhagen, could not provide that coverage if they're not regulated in the US. That has changed now because the administration saw that for their ambitious project, they need more capacity. So they basically agreed that also foreign insurers could provide that coverage if they are recognized and their policy is recognized by the US Department of Health and Human Services. A different issue, that's for, let's say, individual health insurance policies. For group insurance policies, the guidance that was issued end of October was, if you have a group insurance policy that is regulated under a foreign law, i.e. Sweden, that's fine. That is Obamacare compliant. We always had a bad feeling about that, and we told Ergo, well, we don't know whether that sounds too good to be true. And actually, that's not yet in the presentation. It's something we learned 2 days ago. They kind of pulled back and said, yes, if that satisfies certain requirements, so that's also open at the moment. Basically, if you want your health insurance policy that you offer, for example, to expats, to be Obamacare compliant, you must be compliant with the so-called substantially all tests, i.e. you have to comply with substantially all requirements of the Obamacare insurance product. And at least when I look at the German market, the products that are offered in Germany will generally not be compliant, also not substantially compliant, because, and that you see here, you have a few prohibitions or a few kind of qualities that this insurance coverage needs to have. For example, you cannot exclude coverage on the grounds of pre-existing conditions. Something, at least in private health insurance in Germany, is unheard of. Obviously, insurers can decide that they provide coverage, but not for certain illnesses that are pre-existing, or they would kind of increase the premium to have a risk-adequate premium. Again, something that in private health insurance in Germany you need to do to make your regulator happy, and obviously also your shareholders. In the US, it's a no-go in most areas. I think for kind of smokers, you have a certain liberty to kind of increase the premiums to a certain degree, but that's about it. So you cannot be as flexible as you are in Europe, for example. And you, for example, also need to cover mental health and drug abuse treatment, and that's something that, at least in the German private health insurance market, is usually carved out. So basically, the question is, what does that mean? To be honest, exactly nobody knows at the moment. Thing is, we are talking to the regulators. We have the impression they are quite flexible in order to get sufficient coverage, also for expats, and that they may be prepared to kind of waive certain of these requirements or don't look at them too closely. But what that means in detail is still unclear, is not yet tested. I think Ergo is a front runner there, and we are kind of looking into that at the moment, and also in discussions with the US regulator. One thing I can already say, if you have kind of long-term health insurance policies in place with terms and conditions that changed over the decades, it may not be advisable to go through that process, because you don't know the outcome. It might be very expensive, and at the end of the day, you might end up kind of giving this full coverage at a non-risk adequate price. But it may well be attractive for kind of travel insurance products or new expat insurance products. So that's something one can consider, and I think the market there, as far as I'm aware, neither US companies nor European companies are really covering that at the moment. Now, and this is my last slide, and then I will end. How do you approach a compliance review of your business, of your policies? I mean, you can take the view that you would need to kind of look at everything very closely and look at every country where you may have kind of customers who might have moved there, and you need to understand the regulatory environment there in full and so on. But you could also kind of go for a risk-based approach, looking at some kind of heat map. Where are significant numbers of customers of yours? Where have they moved? Which countries are important from a regulatory perspective for your business as a company or as an insurance group? Which countries are likely to have specific regulations, and which countries may have, if you want, draconic sanctions such as imprisonment, and where do you rather need to be compliant, and where could you take the view that a few customers there won't matter? I mean, as a lawyer, that may sound funny, but from a business perspective, I think you don't have a choice. And on that basis, you would develop, in case of Ergo with us, a question catalog for local counsel for us, or lawyers admitted in the various jurisdictions, to kind of test what actions may be problematic and what is all right, so you can adjust your policies, you can adjust your behavior, and you can inform your customers. And obviously you then may also conduct local surveys of the law and your practice in this regard. And obviously, if you're thinking about that, we are more than happy to assist you with that. And here I end. Thank you very much.
Thank you very much for that interesting presentation, and really glad to have you here today to enlighten us on some of the world topics on how to be compliant and challenge the world from a business and from an insurance perspective. So thank you very much for that.
Thank you, Patrick.